based on reading people's facial gestures, the tone of their voice, and other uh, basically biometric factors, there are tools that can actually determine the sentiment of people on the call. Under many state laws, there are requirements under wiretapping laws and similar laws regarding recording conversations, things like confidentiality, right? Some meetings touch on very sensitive topics. Some may be subject to discovery and litigation. Some may involve lawyers or maybe attorney-client privilege.
Welcome, and thank you for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, James Scotto. James Scotto is a partner in Shepherd Mullin's Washington, D.C. office, where he founded and co-leads the firm's 120-plus person artificial intelligence team. With a robust technical background and over 35 years of experience, Jim provides strategic, business-focused advice on all aspects of intellectual property, technology transactions, regulatory issues, and litigation, particularly those driven by innovative business models and disruptive technologies. The webinar presentation that you're about to watch will be approximately 1 hour, and time permitting, James will be taking questions from the audience at the end. So if you have questions that you'd like us to address once the presentation is complete, you can send those in at any time by clicking the Q&A button in the control panel at the bottom of your screen. Now, without further ado, here is James to discuss AI Notetaker Minefield, navigating legal and business risks with AI note-takers and meeting recordings.
Great. Thank you very much, Nina. Well, it's a pleasure to be here. Thank you all for tuning in, and hope you find this very informative. And as Nina mentioned, hopefully I'll cover everything that needs to be covered, but if you have questions, we're happy to take those at the end. Just briefly, just a little bit more about my background. Nina did a good job of introducing me. One update, I'm actually teaching, the last slide shared, I was teaching at Ole Miss. I'm actually teaching at AI Law at George Mason right now. And continue to do, a mix of work in really innovative areas, but largely AI has been kind of the predominant work recently, given the real surge in activity on both the technology front as well as the legislative and litigation front as well. And I've been doing AI work for actually about 25 years now. It's really interesting to see how the field has evolved, and certainly with the advent of generative AI, we're seeing all types of new issues, certainly a rapid proliferation of issues and lawsuits. The topic we're going to cover today, some people say, well, people have been taking notes and recording conversations for years. Why, is there anything different, if you're doing it with AI? So we're going to cover that today, and hopefully you'll walk away with, if you don't already have some appreciation of kind of why it's different. We'll certainly cover that, but then also talk about why those differences create legal issues. So here's just a brief summary of what we're going to cover. I won't read through those and kind of estimated time on each of those topics. So to dive right in, AI recorders and note takers and similar tools are being used ubiquitously by companies and by employees. Many companies are using these tools and provide them on a company-wide basis, but there's also a lot of individual employees that are using these tools. If, for example, the company doesn't provide an enterprise version of one, or if they, have a tool they like that the enterprise hasn't supported. It's important to understand that some of these are standalone tools. So many of you are probably familiar with tools like Otter AI or Fireflies, which predominantly the purpose of the tool is to do AI note-taking and recording. But there's also a growing number of tools that have these functionalities built into them. So if you think of like Zoom or AI, these are, Teams, these are, kind of meeting platforms that do a number of other things, but they built these capabilities in. So when we talk about AI recording and note-taking tools, we're talking about both the standalone tools and other kind of broader platforms that incorporate the functionality. One of the key takeaways that I hope you get from this, if nothing else, is that from a company perspective, it's critical for companies to develop policies on the use of these tools. And we'll go into why and what the policy should cover. But at a high level, there's really two reasons. One is from a legal compliance perspective, it's important to do this. There have been lawsuits. We're going to go through one or two today, examples of where there can be lawsuits, and so there's company liability. But also beyond just complying with the law, there's a number of business interests that a company has that they should be aware of that could be impacted by these tools, and they should incorporate policies that protect their business interests, not just the legal compliance. So one of the first things that's important to understand with these tools, and more broadly, you probably heard this in connection with other AI webinars we've been on, but it's really important to understand that people kind of lump AI tools together as a kind of a label or a category. But it's really important, if you are assessing legal issues, is to really understand the specifics of any tool you're looking at. Because while there's many tools within this category or like any other category of AI, all of these tools work differently. They have some similarities, but they have different features and functions, and they manage information differently, et cetera. And so depending on those variables, and we'll go through some of those in more detail here, there can be different legal issues and different compliance obligations and different business risks. So the first thing that's critical with any analysis, including these types of tools, is to make sure you understand the tools and the range of features and options. So in connection with AI recorders and note takers, there's different functions that these tools perform. And some of them perform, all of these, some perform some subset of them, and some may perform even additional functions that are on this list. But the common elements are many of them will record a conversation, and some record audio only, some record audio and video, some will capture any screen shares as well as the people, the audio and video component. Some will generate a transcript of the recording. Typically, that transcript will be an AI version of the transcript. And we'll come back to that. Why it's important is we all know AI is not perfect. It's very helpful, very useful, but it can lead to errors in some cases. In some cases, the tools will create not just a verbatim transcript or close to verbatim as the AI can get, but it'll create a summary. It'll go through and try to highlight the key points using AI and other algorithms to create a summary. And similarly, some tools will create a to-do list. So to the extent that there's action items that are discussed, some of these tools can actually generate a to-do list and who's responsible if that was addressed on the call. So there's many different outputs that can come from these tools. Those are some of the primary ones. And the other one I want to mention just briefly, and I'll talk about some of the legal issues as we get into the presentation here, is what's referred to as sentiment analysis. And sentiment analysis is actually a really interesting technology, and it's used in a lot of different contexts, not just these tools. But as the name implies, based on reading people's facial gestures, the tone of their voice, and other basically biometric factors, there are tools that can actually determine the sentiment of people on the call. Was someone angry? Was someone scared or kind of nervous to talk? There's a whole different range of sentiments that might come out. And again, while those can be very useful, in some cases there's legal concerns that need to be addressed. So we'll cover that. But so this is kind of a high level set of the functionality. Again, there may be other ones in particular tools that you look at, and we'll kind of focus most on these today. The other things is that some of these tools, in addition to the basic functionality, they may provide other features. So as we'll talk about a little bit today, one of the things that's important when you're doing recordings of conferences is notice and consent. And in some cases, there's different ways to deal with that. You can deal with it manually, or some of these tools have features that will help with notice and consent management. Another kind of big category of features of these tools is that if we think of the recordings, the transcripts, the summaries, the to-dos, and the sentiment analysis as, each of those create some unique output of these tools. One of the questions is, what happens with that output? And this is one of the places where, some of these AI tools differ from someone just, handwriting notes. If you have a secretary of a corporation taking notes of a board meeting, for example, with some of these tools, the output is only provided to the host. Whoever was hosting the meeting gets the output, and then they can do what they want with it. They can share it or not share it based on a number of factors. Some of these tools, however, will automatically send the output to all of the participants. As I'm sure you can imagine, there may be situations where that may not be desirable. And so we'll talk about some of that. And then a third category of sometimes what happens with the output is it doesn't just go to the participants, but in some cases, the tool provider. So in the case of an AI tool, whoever the company is that built that tool, they may be operating this as a service, for example, as a SaaS-based service. In some cases, they actually retain a copy and they may use it for further training their tool or other purposes. As we'll see, that's actually particularly problematic from a legal perspective. And so we'll talk about that. But the kind of the key takeaway for this slide here is it's really critical to understand what outputs are generated and what happens with them. And with some of the tools, things happen automatically. And in some tools, particularly enterprise versions, you can have an admin dictate what will happen, right, as a default matter. So you're not leaving it up to individuals to make decisions or decide what they want to do with the outputs. And kind of related to that, in addition to who gets the outputs, you have to understand where, if anything, where are these outputs stored? Is a copy just provided to the host, or is there a copy stored on a server somewhere? Some of these tools have their own file repositories, and so you'll have a copy there. And if you share it, and if you have let's say a document management program, you may store these notes in your firm's file document management system. So now it may be in at least two locations. As we'll see when we get into things like record retention and document management, that can be an issue, or at least something that needs to be factored into with respect to those policies. And going the last point here, I kind of touched on is, if the tool provider gets a copy of the output, do they use it? And if so, for what purposes? And we'll see why that's important in a moment. Okay, so the first issue really to think about is under many state laws, there are requirements under wiretapping laws and similar laws regarding recording conversations. Some states, if one party to a conversation agrees to record, then it's legal to record in that state. So if it's just me and Nina on a call and I decide I want to report it, I don't have to get her consent if it's a one-party state. But in many states, it's an all-party consent, meaning every participant to a call, if it's being recorded, has to get notice of the recording and they have to consent to it. So there's a transparency requirement under most state laws and under federal law, under the federal wiretapping laws, these issues are relevant. So one of the questions that always comes up, and this is typical in a lot of areas when you're dealing with policies or compliance, it's easy to say you need notice and consent. The more difficult question is, how do you actually implement that? So, notice is relatively easy. Many tools these days, if they're recording, and I'm sure you've all seen this, there'll be a thing that pops up at the beginning of the call saying this call is being, or this session or webinar is being recorded. Okay, that's fine. Where does the consent part come in? That's where it gets a little more difficult. For many of the tools that are out there, there is not necessarily a tool or a feature built into the tool that requires people to affirmatively agree and consent to it being recorded. There's a notice, and some people believe that as long as you're given notice, if people decide they want to stay in the meeting and talk after and appear on video after the notice is given, that's an implied consent. Well, many of the relevant laws don't expressly provide for implied consent. So some people do that and think that's going to be okay. And maybe in some places it will be. But if you want to be safe, you really need to have affirmative consent. And so how do you deal with that? Again, that gets a little more difficult. Some people will send out notices before a meeting to all the participants saying, just give you a heads up in advance, this is going to be recorded. If you agree to that, respond, and you'll have an email record that everyone has consented. And if someone doesn't consent, you can deal with that, either disinvite them or figure out another way to either not have them participate, or in some cases, people will decide not to record a meeting if one or more people object and there's a reason for not wanting it. So the manual approach is one way to do it, but of course not the most efficient. Some of these tools will add additional features, though. And so one of the features is that there'll be a notice that this meeting is being recorded, and you'll see with that, it will say, if you agree to be recorded, click here. And that notice will not go away until you click. So that's helpful. But what if someone doesn't click and they still talk? What some of the tools do is go a little bit further. And as you may guess, these are the tools I'd recommend using. It won't let people be seen or heard on a call unless they actually consent. So they can listen, but they're not being recorded. So again, there may be other options out there for either manual or some of these tools having features, but one way or another, it's really important to understand what the notice and consent requirements are and to manage them. Given the fact that many people work remotely these days, you sometimes don't know where somebody is when they're calling in. And often the state law applies where someone is when they make the call. So I think it's safe to assume in all cases that you need consent from everybody. It may not be necessary, but you're going to be safer by doing that. Okay. Next topic is accuracy. So as I mentioned, some of these tools will create a transcript, a summary, or to-dos. In many cases, AI does a good job of creating a transcript, but it's definitely not perfect. And so we'll see that it's important to review the outputs of these tools. And from a business interest perspective, I'm going to cover some of these in more detail. You want to think about things like confidentiality, right? Some meetings touch on very sensitive topics. Some may be subject to discovery and litigation. Some may involve lawyers or maybe attorney-client privilege. So you want to think about access controls with respect to any of those recordings or outputs. And then, as I touched on earlier, it's important to have a policy regarding retention and deletion of these documents. So summaries and transcripts are all documents that should be managed to avoid business problems. And you typically want, most companies have a document retention policy. So this is an example of where you want your AI recording policy to be woven into your retention policy. Or if you're going to have one standalone, you want to make sure they cross-reference each other. And then it's also important to conduct vendor diligence. So anytime a company, adopts a tool, their IT department typically will go through standard diligence regarding security and privacy and other technical features on the diligence checklist that are typically relevant for almost any tool that you're going to, license in or require. But there's unique issues that arise in connection with AI tools in general and AI recording and note-taking tools specifically. Okay, so I covered some of the transparency stuff here. So let me go to the next slide. The participants, we talked about that. How do you manage the participants that don't consent? Ideally, when you're selecting tools, you want to find tools that have pretty effective features for this, so you don't have to leave it up to individuals or to do it manually. And it's important, in my view, that your AI note-taking policy have approved methods for managing this. Some companies won't permit manual processes. It's just too cumbersome. Too much can slip through the cracks. There's too much, needing to document the emails and kind of save them and all that. Some will only approve tools that have features that the tools themselves handle. Okay, so what are some of the laws that apply here? So one of the federal laws is the federal wiretapping law, which is indicated here, and this generally relates to the interception and disclosure of information over a wire, whether oral or otherwise, or other electronic communications. Then there's various state laws. I haven't listed them all out, but one of the laws that is pretty prominent, and there's been some litigation involving, is California's law, which is indicated here, which imposes both civil and criminal liability on not only individuals who engage in illegal activity, but aid and abet third parties who eavesdrop on communications or intentionally intercept communications without obtaining consent. And so to unpack that, it's illegal for you to record something that you don't have a right to record. It's also illegal for anyone to aid and abet someone in doing that. So what does that mean, or how does that relate to this context? So if you are a company that adopts an AI note-taking or recording tool, and you use that and you kind of make it available to your employees, and they're using it, and it turns out that AI tool provider is making a copy and using that copy, you may be liable for aiding and abetting their illegal services. And so you say, well, how does that happen? I mean, if the tool company is able to make a recording for you, why is it illegal for them to maintain a copy and to use it? And the main reason is that it goes to the disclosure part is part of it, because in most cases, these tools don't say the tool provider is making a copy and using it. It just says the meeting host is recording this conversation. And so the participants, in most cases, do not have notice that a third party, someone who's not a party to the conversation, is going to get access to and be able to use this recording. So that's just one example of where you using a tool can create that liability. And this is another reason, and I'll point out some others as we go through, that it's really critical as for any AI tool you adopt, that you do standard technology diligence that's always done, but you have to understand the specific legal issues that can arise with that tool from an AI perspective, and conduct additional diligence based on those factors. So in this case, as I mentioned in the prior slides, you want to, as you're conducting diligence, you want to understand, what are all the features of the tool? What are all the outputs? Where do they go? Does the tool provider keep any, and what do they do with them, et cetera? And if you don't conduct that diligence, you may be liable under these and similar statutes. Just one kind of broader note, if for those of you who are familiar with the Colorado AI Act, which was passed and comes into force next February, That law specifically provides that both deployers and developers of AI have an obligation to ensure that AI tools are used in a legally compliant manner. And it imposes liability on the people who deploy it, users, enterprises that use third-party tools. You can't, as a defense, if the tool does something that's illegal under your use, you can't turn around and say, well, we didn't build this, we're just using a third-party tool. The whole point of that law is to make sure that companies that are adopting third-party technology conduct diligence and assume responsibility for the tools that they deploy. And as part of that law, developers have to cooperate with their customers that are deploying the tools to provide the relevant information. So this is, that's kind of a general principle, but it clearly applies here. And it's important to, think about that as you're doing diligence. Where are some of these unique issues and what do we need to do to make sure that the tools we're deploying are safe and legally compliant? So there's been a number of lawsuits on these topics. I'm really going to cover this primary one. I think it shows kind of a classic example of some of the issues I just been talking about. So there was a lawsuit filed against Heartland Dental and Ring Central. And Heartland Dental is kind of like as I understand it, it's kind of like a service organization for dental practices. So they provide platforms and technology for managing these offices. And one of the tools that they adopted was a AI recording and note-taking tool provided by Ring Central. So they made it available to the participating dental offices that were in the Heartland group. And the tool recorded conversations between, basically visits between a dentist and their patient. It performed AI analysis on those calls. And in this case, some of those recordings were stored and by Ring, and notice was not given to the dental patients. So the allegations, related to the federal wiretapping that I mentioned was one of the primary causes of action. And the allegations were pretty much along the lines of what I had talked about. They're saying that a third-party service, in this case Ring, recorded patient calls with the dental service, and Ring was not a party to the calls. It had listened to and analyzed the calls using its tools and maintained a copy. So, this lawsuit is still pending, but it's, I think an example of we're going to see more of these because these tools are becoming more ubiquitous. And I can tell you that a lot of companies don't have policies on these, and a lot of companies aren't adopting an enterprise tool. They're, letting employees use, I won't name names, but use tools that are just consumer versions. And most of the consumer versions, which are free, as you know, there's usually something that goes along with that where they're collecting data. And if the tool is free, you're the product, right? So it's really important for companies to understand that, these aren't theoretical risks. There are lawsuits that are being filed. Okay. On the accuracy part, this I can probably go through pretty quickly because I'm sure most of you are pretty familiar with this. But if you think about like a transcript, if you have an output of one of these tools and it's a transcript of a meeting, and at the end of the meeting, the host just kind of stores that in a file management system somewhere, and doesn't review it. It may be down the road, someone pulls up the transcript to hear what was discussed, and there can be one word that the AI missed or misinterpreted, and it can change the entire meaning. And it's possible that may come up in a business context. It's possible that could come up in a litigation context. But as a very simple example, if the speaker in a call says, "Hey, he didn't know the product was dangerous," but the transcript said he did know the product was dangerous, obviously you wouldn't want that coming out in a product liability case down the road. Oh, you can always try to say, "Oh, that's not what was actually said." You're better off having someone review the transcript or the summaries or really any of the outputs that are, kind of AI generated to make sure they're accurate at the time, right in proximity to when the meeting is over. And so you can correct that and you don't store something that has misinformation. So that should be pretty obvious. But many companies will actually mandate this as a policy, and in some cases, companies will require two different people to actually review it, just to kind of make sure someone doesn't try to slant the conversation. You shouldn't have that situation in a company, but sometimes that happens. So different policies can be adopted to address these types of issues. Confidentiality and privilege. So again, many of these, the issues are probably pretty apparent. But what you do about them is kind of what we'll cover in a little more detail. So there's many times you're having a confidential conversation, but as I mentioned, in some cases, the tools automatically send a transcript or other outputs to all the participants. There's many situations where you may not want that. If the meeting includes non-employees, there may be a meeting you have, and it can be, with customers, partners, contractors. I mean, they may be under, an NDA, or there may be, they understand, that the call is confidential. But if a output gets sent to them automatically, you now have a copy outside of your organization that's potentially floating around and could be either intentionally or inadvertently shared. So, one of the, kind of simple things, again, this is not so much, there's a legal aspect to this. If it's confidential or trade secret information, you want to maintain confidentiality, otherwise you lose it. So having controls can help protect the business interest there. And so it's critical to have some level of access control with respect to these documents. So how do you do that? How do you manage that? So many companies have document management policies as it is with respect to, maintaining confidential information and trade secrets. And so these AI policies should dovetail with those. They should kind of work together with those policies, and then take into account any unique situations here. As I mentioned, you want to understand where, what are all the outputs that are generated, where do they go, and/or where do they get stored? So obviously the safest thing to do is to have a tool that only provides the outputs to the host. And then depending on the company's policy, the host may share with one or more of the participants, depending on the need and other factors within the policy. It's also important, as I mentioned, to understand where documents get stored. So again, if you email a copy to the host of a recording or a transcript, obviously they'll have a copy in their email. But for many of these tools, so if it's like a cloud-based service, there may be a copy that lives in the cloud. So the question is, who at the company has access to that version of what's stored? So you may have multiple copies in different locations. And of course, if it gets shared with participants, then you may have even more copies. And so all of that is, it's important to manage that. So only the people who really have a need to know this confidential information get it. But then the other thing that's important is thinking about from the standpoint of document retention policies and document deletion policies. If the meeting host just deletes his copy in the email or her copy in the email, but there's still a recording on a server somewhere, that document is not deleted. And if it should have been under a document, deleted under a document retention policy, that can lead to issues down the road. It's also, I think, important if you're going to implement, which I think you should, a review process where the output, it gets reviewed before it's shared. If it's going to be shared, it's good to, again, have, one or two people who have access to the original outputs. They review it. Once it's approved, if any edits are made, only the correct version gets sent around to anyone else who has permission to get access to the document, so that you don't have conflicting versions floating around. And in those cases, any versions that may be stored anywhere that are inaccurate should obviously clearly be deleted. Similar issues apply with respect to privilege. When you're dealing with attorneys, of course, that's still confidential information, but there may be even, a greater need to be careful who gets documents. So with company confidential information, generally if it stays within the company, it maintains its confidentiality status, assuming no one leaks it. But with attorney-client privilege under, existing law, you can't just share privileged documents with anyone in the company. Typically, for privilege to apply and be maintained, there has to be a communication involving a request for legal advice or related services, and the information typically can't go to people who weren't involved in that process, because you can lose attorney-client privilege if it's shared too broadly. Some states have this controlled group test, and there's other tests state by state, but it's important to really factor in the relevant, privilege management issues with respect to these documents. Similarly, I think it's particularly important, anything involving lawyers, that you have accurate facts, because anything is going to legal department, while there may be privilege, as you all know, it's not absolute. And so if you have anything that's erroneous, that's in a, legal file, that's going to be even more problematic in litigation. So I mentioned these sentiment analysis and emotion detection tools. This could be a whole 1 hour seminar on its own, and it's really interesting. Um, but I won't take up too much time on it, but I do want to mention it just more for your awareness. These tools are being used in a lot of different ways. Some of these have been, and some are AI based, some are not, but most of these days are AI based. But we've seen these tools in many contexts. So I don't know if any of you have seen this, but some emails have features where if you prepare an email, and we'll call it a hot email, right? Something that you're kind of pissed off at, and you write kind of a snarky response to somebody. Some of these tools will if they detect based on whatever the policy is that's set, if they detect that you are emotionally hot when you're writing an email, it actually will hold that email for a period of time, send you a note saying it's being held, saying this might be, interpreted by the recipient as angry or whatever the determination is. Would you like to rewrite it? So that's a pretty simple and basic one. But we're also seeing much more complex use of sentiment analysis in connection with AI. And so the way that this works, many of you may know, you probably heard of people in law enforcement being able to read someone's face and detect if they're lying. There's many books that are written on this topic, and face expressions, voice tones, and other biometric or physiological signals are pretty telling with respect to different aspects of someone's sentiment or emotion and veracity. And so these AI tools have gotten pretty good at using facial features. So there's some tools that use that read eye data, so blink rate, pupil dilation, eye movement, and other biometric factors. And using this and the science behind it, they can do a pretty good job of detecting emotion and sentiment. So from a legal perspective, one of the reasons that this creates a problem is that, as you all know, privacy information, personal information is protected, but there's even greater protection under certain laws when you're using any biometric based privacy information. So biometrics being facial features, eyes, voice, other features of a person, biometric or physiological features of a person. So there's aspects of this under the EU GDPR. I think the EU Act has some aspects with respect to biometric analysis and emotion detection. California's Consumer Privacy Act, the BIPA, the Biometric Information Privacy Act under Illinois, and many others. And so whenever you're using biometric data, there's a greater sensitivity, and there may be additional laws that are relevant and need to be considered. And so whether it's in connection with these AI recording tools or otherwise, it's just something that is, I think underappreciated by some people that I speak with. And when you dig into it, you realize there's actually a fair amount there. There's a link to an article there from, I think it's an ABA article on some of these issues. I won't go into it any further, but I think that's important to be mindful of. Okay, so access control, we talked about who gets a copy, where is it stored, who can access it, we covered that. Okay, retention and deletion policy. So this, as I mentioned, most companies have a document retention and deletion policy. If you're in a regulated industry, you may have to maintain documents for a certain period of time by statute or regulation. And in those cases, you want to ensure the documents that you must maintain are not deleted, or you could have regulatory problems. But so subject to your existing policies, you want to factor in the outputs that are generated by these AI note-taking and recording tools. And I think it's important to think about the different outputs that are being generated, because the answer may be different for different ones of those tools. If there's a to-do list, it may be that you can delete that once everyone's been assigned their task, and whether it's an email that goes out or calendar reminders, whatever. That might be the easiest, and some of those may or may not be subject to regulatory retention requirements. Transcripts and summaries probably fall into different categories. So the short of it is that there may be within your policy different retention periods for different types of outputs. You want to think about how long do you want to keep these for. So absent a statutory requirement, again, a lot of companies are managing these types of outputs, these documents, consistent with their other retention and deletion policies. But in other cases, companies are not keeping the AI transcripts around very long once they've been used, whatever purpose you want for the transcript. In some cases, companies are just keeping the summaries and deleting the transcripts because they don't want a full record of what was said or who said it. In some cases, you want to just have a summary of what was said, not necessarily who said it, for example. In other cases, it may be the opposite. It's also important to think about, regardless of what your policy is, if the company is subject to a litigation hold, which, as most of you probably know, is that when you're in litigation, or even if there's a threat of litigation, you may be required to not delete documents that may be relevant to the issues and subject to discovery in that litigation. And so, to the extent that your policy on these keeping these documents, it says you can delete it after a year. If there's pending litigation and that subject was discussed in one of these meetings, you may have to keep those documents a bit longer. And then the last thing is, and this applies to other aspects of this as well, is that one of the challenges companies have is, they have a lot of existing policies already within the company. Then they have like their AI policies, and there's definitely some overlap, right? So like in this example, you want to have a document retention policy for these AI generated outputs. You may have, a separate policy. And so, in some cases, companies will actually have a policy appear in both documents. So you may have a specific document that's AI document retention for AI note takers and recorders. And you'll list out what the policy is, and then you'll repeat that, or at least have a link to that in your general document retention policy. So there's different ways, but it's important for completeness, in my view, that if you have a general document retention policy, you should at least reference, if not incorporate, the AI specific aspects in that policy. Okay, vendor diligence. So I've touched on this. I'm going to kind of go through some other examples in a little bit more detail. So everyone knows when you're doing diligence on a tool, you want to make sure that you've checked out that it's secure from a cybersecurity perspective. You want to make sure that you get support where you need it. You want to make sure that it you understand what data it's collecting, how the data is being managed, and all of those types of things. it's important, given the AI aspect of this, to really, understand deeper what are all the features, functions, options, outputs, etc., of these AI tools, and really drill down on them. And typically that is done mostly by the technology group within a company. We've worked with many of these groups to help them identify for a particular tool what are some of the areas they should be asking about from a technical perspective. What should they be looking for? Because in many cases, and tech folks are pretty smart, but they're not lawyers, so sometimes they understand the technology aspects very well, but they may not understand. If you give them just a list of questions, they may not understand the legal significance. So it's important that they coordinate with, or in some cases, have attorneys work with them on the diligence. It's also important from, and again, this should probably go without saying, but we've seen situations where this has been overlooked. The terms of service and privacy policies for these AI tools need to be reviewed carefully. In many cases, the tools are the terms are pretty upfront about what they're doing, like they're maintaining a copy and using it. In other cases, you'll find the terms of service are inconsistent with how the tool actually works. That should be a big red flag. Whenever we see that a tool has features that should be disclosed or addressed, and they're not, or they're addressed but it's inconsistent with what turns up in the technical diligence, you have to really be careful with those companies, because a lot of them, where there's one or more issues like this, there's generally others as well. And so part of the diligence you do is, what's the reputation and, kind of compliance history of the tool provider, right? Are they, taking AI and other legal regulatory issues seriously, or are they just pushing stuff out pretty quickly? So all of that is important. I mentioned earlier the Colorado AI Act kind of mandates essentially that you do vendor diligence. So I'll kind of not repeat that one. You want to understand, I think it's really important to understand what, if anything, the vendor gets and what they use for its purposes. And then once you understand the tools and the features, if you're going to adopt a tool for enterprise use, which I generally recommend in most cases, if companies are going to deploy a tool, they get the enterprise version for many reasons. But one of them is that you can have uniformity within the company, right? And so you won't have, if you don't adopt an AI tool, users are going to use, employees are going to use ChatGPT or other tools on their own, and it's going to be a nightmare from a legal perspective. So companies are, for the tools that they want to make available and should make available to their employees, having the enterprise version is important. And one of the advantages is that many of the enterprise tools are built from the reputable vendors, have built-in features to help with legal compliance. They understand what these legal issues are, and they understand the challenges of companies. And they've gone through diligence with companies saying, well, how do I manage notice of consent? Does your tool provide it? If the answer is no, then they're going to go to someone else. So more of these companies are building these features in to their tools. And so there's different settings and options that an administrator can set that will, in some cases, it just automatically gets deployed and it's locked down company-wide, so that you don't have employees having an option to change some of these settings. Other settings, they may be settable by, there can be a default that's set by the admin, but that there can be a range of options that may be permissible under a company's policy that users can select. But it's important to have kind of company control over that and decide what should users be able to select and what shouldn't they be. And for the selections, what's the range of options you want to give them? Okay, and we talked about AI sentiment and emotion detection. Okay. Okay. So kind of get to the kind of the final key takeaway here. As I mentioned, the most important thing is you probably have assumed by now, is it's really critical for companies to develop policies on many aspects of AI, but AI note takers and recorders is one. So here's, again, each situation is different, so I'll just caveat it. These are some of the common areas and elements that we'll see. I've covered most of these, so most of these should be pretty clear, but I'll elaborate on a couple. But it's important, I want to underscore that each tool is different and there may be unique issues that arise with certain tools that aren't on this list. So this is a starting point. And some of these features may not be relevant in some of the tools. So make sure you understand the tool, think through any unique legal issues, and then the policy should be developed, around that. So we talked about the, transparency, notice, and consent. Um, again, I think ideally, from a policy perspective, as I mentioned, some companies will mandate only use of certain tools, right? And they'll only approve certain tools, and any tool that's not approved, you cannot use. That's literally how many of the policies are written, so that the company has control over what's used. And if someone wants to use a tool, they can, make a request and, explain why and all that, and the company consider whether to add it. But I think that it's best to, from a uniformity perspective, is to have, enterprise versions where you can control it. And so from the transparency, noticing consent provision that I mentioned, it's best to have a tool, if you're going to adopt one, to have one that has those consent management features built into the tool. And so your policy can say, you have to use, these settings or these features. And you can have information like what if someone doesn't consent, but they still wanted to participate. You can deal with some of the outlier cases, but the vast majority of what needs to be covered is done automatically. The applicability of the wiretapping laws, again, the main thing we see here in the policies is most companies will just by default assume that all parties need to consent, and that the federal wiretapping laws apply, and that the states, whether it's one party consent or two party consent, they'll just you know go to the least common denominator and be the safest. So again, that by policy you could have that be different, but I think it's really hard to manage. Reviewing for accuracy, as I touched on earlier, some companies get somewhat granular with this, and in some cases it depends on the nature of the subject matter of the meeting, as far as how much review has to be done, whether it's one person or more than one person. If there's changes that are made, do you keep the original version and the revised version, or do you just keep the revised version? There's different ways companies deal with that. The retention and deletion, again, on that, from a policy perspective, I think the key thing I touched on earlier is really you want, as much as possible, you want all of these AI specific policies to work with any existing policies that you have. So for the most part, you want this to dovetail as much as possible with your existing document retention and deletion policies. But there are, aspects of AI, as I touched on, where, you may want to depart from that for specific outputs of one of these tools, right? And for others, you may not, you may not have any difference from your main retention deletion policy. The vendor diligence, that I touched on that. I think one of the things that, as I briefly mentioned, companies have to decide, right? Do they want to, do diligence on these tools at an enterprise level? Do they want to only adopt tools if the company, specifically approves and prohibit any others? Or we've seen in some cases where it may not be a big deal for certain companies. They provide guidelines to employees on, you can use, here's the approved tools, you can use other tools as long as you meet these conditions. And, so some companies are a little bit more flexible, particularly smaller companies that, may not be able to get an enterprise tool for each of these, kind of features and functions, that we're talking about. And so they have to be a little bit more flexible. Obviously that flexibility creates a little bit greater legal risk because, in some cases, employees won't understand what the, kind of criteria are. In some cases, employees may understand it, but not, fully apply it. And it may be intentional or unintentional. The intentional can be, yeah, I'm going to use this tool regardless of what the company says. But in other cases, it may say you can't use, an AI tool if it does sentiment analysis. employee may or may not know whether a tool has sentiment analysis. So it may not be, that it's an intentional violation. But, just, I don't need to belabor that much more. That I think is pretty clear that the more you leave to employees, the more chance there is that even if your policy is clear, you may not get compliant, and that can create potential legal risk. It's also, in addition to like cross-referencing your document retention policy with whatever the AI policy is for retention, you want to really think about your, as necessary, updating any other policy. So, if you're, interfacing with customers and you're using these tools, you may want to put something in your terms of service or in your privacy policy. So, depending on, the way you're using these tools, I mean, some of these are used just for internal meetings, but some of these tools people use in connection with customer service and other purposes. And what I'll tell you is that what we see, the inclination, and I'm not attributing anything, necessarily nefarious in the intention here, but many attorneys want to keep things as simple as possible and as broad as possible. And, we often see in a terms of service that, we may, you make a recording and use it for quality assurance purposes. You've all heard that when you're on a phone call with customer service or otherwise. If you're going to use that for AI purposes, for training, if you're going to do sentiment analysis, which some companies have done, like United Airlines had a lawsuit because they were doing sentiment analysis on customer calls without disclosure. If you have a general disclosure that as a lawyer, you think, well, this might cover what we're doing. The FTC has pretty much said that you got to be pretty specific about this, particularly with AI. So if you're using AI, particularly if you're using it to train models or do something else, there's guidance out there, and there've been some enforcement actions when there's been lack of clarity. So I think it's important as part of your developing these policies that you update whatever documents you need, and that you're pretty upfront. I always kind of say that there's this desire to kind of keep things broad and maybe not tell customers exactly what you're doing. But I always say that if you don't want to tell your customers what you're doing, you want to really think about whether you should be doing that. So, this is where that kind of issue comes out a lot, is if you write something specific and the business says, well, we don't really want to tell customers, that's kind of a red flag. Last couple of things I would just say is that, and again, this probably goes without saying, but it's really important. Many companies develop policies. They publish them. No one reads them. They sit in the legal department in a book somewhere or on a server. That's not really a policy, right? That's kind of a wish list. I think it's really important for any policies that you develop. Employees need to be trained on it. They need to understand like the purpose of this. They need to understand, why compliance is important. They need to understand why certain options are made, so that they kind of get more buy-in if they understand there's a real reason for it, as opposed to just, procedural impediments to their day. But it's also important because there's a lot of things that, especially if you leave things up to employees to make certain decisions, it's even more critical that they be trained on, the things that are in the policy. Where might there be other issues, or, where might things arise that they may not be readily apparent to them. And so that's important. And then the other thing is with policies is this is not a one-time thing. It's real, the law in the field of AI and the technology is changing, and it's creating new legal issues. And so there's a lot of federal bills. There's hundreds of bills pending in state legislatures right now, and most of the federal and state agencies are issuing guidance on various topics, and there's litigation that's ongoing, and from the litigation, we're learning what companies should and shouldn't do. And so it's important for companies, as you develop a policy, that you need to more so than in other cases, you need to monitor developments frequently. We recommend at least every 3 months, and then make any updates to your policy that are warranted based on changes in the law and how you want to adapt to that. So with that, I see I am at time. Happy to answer any questions if there are any.
Awesome. Thanks, Jim. We do have time for a few questions. As a reminder, if you want to share your question with Jim, you can go ahead and do so by clicking the Q&A button in the control panel at the bottom of your screen. It looks like we already have a few, so I'll go ahead and go through them. The first one is from an anonymous attendee. They ask, is there specific verbiage that needs to be explicit for the recording using AI, or is something like the Zoom recording notification sufficient?
Yeah, I'm not aware of any regulatory mandate on specific language. I think the guidance is it has to be clear and complete and accurate, right? And so if you're just doing a video recording, you say this is being video recorded, or there's video and audio. I think it's best just to state that. And then if there's, depending on what you're doing with it, that's where it gets a little bit iffier as far as whether you just notice of recording. But it depends on whether you have internal participants only or external. There may be different factors. But I think that it's better to be clearer than you don't want to have a 1-page document coming up at the beginning of a meeting, but you want to be as clear as you can so no one can say, well, I didn't realize you were that was going to happen, for example.
Thank you. Our next question is from Osley. They ask, you mentioned that sometimes AI note takers can mistranscribe or hallucinate, and that can completely shift the course of a case. What are your thoughts on who would be liable in such a situation, and how can we best manage or limit that risk in addition to the ways you mentioned?
Yeah, it's a great question. So I think, at the high level, if it's a company recording and it creates an issue to the company's going to be, they're the ones going to bear the liability. Is there a liability for the reporting being inaccurate? I think that depends. There may not be an independent cause of action on a part of a third party, right? If a company gets sued, it's their loss. But if there could be situations where if there could be, let's say, in the limited cases where there's personal liability for corporate officers, for example, which is pretty rare, potentially there could be an issue that arises, on the part of an individual if they were a party to one of these conversations, if it came out. But I'm not aware of anything in this context where the hallucination or false information creates separate liability. Outside of the reporting context, there certainly is some information there, but generally, it's either going to be that there was a case involving defamation, for example, and the tool in that particular case, the tool company was found not liable in part because they had disclosures, and in part it was the use of the output wouldn't have been reasonable was determined. So it really is fact specific depending on the type of legal issue that arises.
Thank you, Jen. All right, we've got two more questions and then we'll wrap up. This next question is from an anonymous attendee. They ask, how should attorneys determine whether a client's or firm's use of an AI note taker qualifies as a quote unquote recording under federal and state wiretapping laws?
So I think with respect to recording, some of the statutes define that, or at least provide categories, right? But generally, if you are taking either audio or video and creating a record of it, in some cases it could be text, that is going to be deemed a recording. But it could be. I'm not aware of really too much in the way of variation in definitions, but generally creating a record of a audio or video session. There could be text or graphics that are captured as well.
Thanks, Jim. And our last question for today comes from Robert. They ask, do you have a compilation or index of recent cases or a resource that we could find for attorneys that may have been censured for misuse of AI or anything with court submissions where this issue has come up? How would they go about finding these cases?
I'm trying to think if I have I've certainly done presentations on AI ethics, and there's different. So I'm not aware of one source right now. I know many of the bar associations have issued guidance on attorney ethics and AI, and many courts have their own local rules on whether in some cases courts have prohibited the use of AI in connection with briefs, and others you have to disclose that you used it, and others you're just going to certify that you've verified the output. So there's a lot of different aspects of attorney AI ethics, but I'm not aware of a single source to answer the question directly.
Thank you, Jim. Well, we appreciate your presentation and you taking the time to answer our audience questions. And thank you to all of our audience members for submitting your questions. We want to thank you all so much for joining us for another Justia webinar. Before you go, don't forget that Justia Connect Pro does give you access to that CLE credit opportunity through select live and on-demand webinars, so you can stay informed and meet all of your requirements in your time. Plus, Pro members also receive an enhanced directory profile, the AI-powered Justia chat to boost your leads, and $200 off of select Justia marketing solutions. To upgrade or learn more, you can go to pro.justia.com. Thank you all so much for your time and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.